You know that old saying, sticks and stones may break my bones, but words will never hurt me. Well, let's talk about that because in the eyes of the law, that's just not true, is it? Words, pictures, even a simple gesture, they absolutely can hurt, and often, in ways much deeper than just a physical injury. Today, we're diving deep into defamation law, that's libel and slander. And honestly, it's a really complex area full of fascinating twists. Our mission, really, is to understand why our reputation is protected, how the law tries to do that, and the surprisingly tricky elements you need for a successful claim. We'll also look at some of the controversies and how this law is, well, constantly trying to catch up with our digital world.
Absolutely. And what's really at the core of defamation law is this critical balance. It's often quite difficult. On one hand, you've got this profound need to protect someone's reputation, and as we'll see, it can be seriously damaged by false statements. But then, on the other hand, there's the fundamental right to freedom of expression. And that tension, that constant push and pull between these two vital things, that really defines this whole area of law.
So why do we protect reputation so strongly? I mean, we get physical harm or economic harm like losing money, but harm to reputation. It feels a bit less tangible, maybe. Can words really cause serious damage?
Oh, definitely. Think about a politician. A tarnished reputation, even from lies, could mean losing votes. It could end a career. Or a business. False claims could lead to a huge drop in sales, maybe even bankruptcy.
And we see this playing out in some really high-profile cases, don't we? Celebrities, for instance, like the actor Johnny Depp. He went through some very expensive court battles in two different countries. In 2020, his libel case in the UK against a newspaper. Well, the judge decided in favor of the newspaper there.
That's right, but it didn't stop there. He then brought another defamation action in 2022, this time in the U.S., against Amber Heard herself. And in that case, the outcome was largely in his favor. The jury found she had defamed him in an opinion piece, even though she hadn't named him directly.
Wow. It just shows the incredible expense and effort someone might go to just to protect their reputation. It makes you wonder, doesn't it? How does a regular person clear their name if even a global star has to fight so hard across different countries?
That's a really important point. And it's not just the famous people or big businesses. Reputation matters deeply in everyday life, too. Especially now, with the internet and social media reaching everywhere.
It really does. Let's take an example. Think about someone like Farouk. Married, couple of kids, volunteers for a local charity, really involved in his community. Now imagine the CEO of a development company whose plans Farouk helped stop is angry. The CEO sees Farouk out with a woman who isn't his wife, just an old colleague actually, and immediately posts on social media, just saw Farouk cheating, can't trust him. Instantly, Farouk's facing online abuse, his wife's stressed, his son's getting bullied, and the charity asks him to step back because of his image. So he hasn't lost his job or his marriage, but that one false post. It causes huge ripples. Where's the line? What level of harm is enough?
That example really shows the insidious nature of online harm, and it raises that crucial question about the threshold of damage the law requires. Now, think about Sarah. She runs a small business making teddy bears. It's her passion. Her employee, Thomas, accidentally emails his grandson, Vincent, saying he earns £10 for 6 hours instead of the correct £100. Vincent is furious, genuinely thinks his grandfather is being exploited, and posts reviews accusing Sarah of modern slavery and sweatshop labor. Sarah's business is now about to collapse. Employees might lose their jobs. She's facing bankruptcy.
That's just devastating. And Vincent, his intentions seemed good, didn't they? Even though he was completely wrong. He thought he was fighting injustice. So should his good intentions matter when the impact is so severe? It really highlights that clash between, well, intent and impact. And what about Ronnie, a landscape architect? Someone called Haley posts online that he's dodgy and has awful attention to detail. Ronnie thinks this might have cost him a job. Should you be able to sue someone just for insulting you on social media? When does an insult cross the line into being legally actionable?
These scenarios bring us right back to that fundamental tension we talked about. Defamation law has to strike this very, very delicate balance, protect reputation, but also uphold free speech. Journalists, campaigners, just ordinary people expressing opinions. They need to be able to criticize and speak out without constant fear of being sued. It's a real tightrope walk.
Okay, so understanding that tightrope walk, how does the law actually go about protecting reputation? It started in common law, right? Shaped by judges over centuries. But then Parliament stepped in, particularly with the Defamation Act 2013.
Yes, the 2013 Act was a major overhaul. It brought in two really significant changes. First, it made bringing claims harder, mainly by introducing this serious harm requirement for everyone. And second, it reformed and sort of clarified a number of the defenses available. A big aim was to tackle something called libel tourism.
Libel tourism, that sounds intriguing. What exactly was going on there?
Well, it wasn't a holiday. It was
Okay.
basically claimants shopping around for the legal system where they thought they had the best chance of winning, even if their connection to that country was pretty minimal. England and Wales got this reputation, rightly or wrongly, as being very claimant-friendly for defamation. You had cases like Berezovsky v. Forbes, where a claim was allowed even though less than 1% of the magazine's readers were actually here. That really fueled the controversy. So the 2013 Act tried to tighten that up, making it harder to sue here if the publication had very little reach in the UK.
Ah, okay. So the feeling was it had become too easy to sue here, and that was potentially silencing people. I remember hearing about the libel reform campaign around 2009. They had some strong arguments for changing the law, didn't they?
They certainly did. Their main point was that the existing law was chilling free speech. They argued it limited expression, stopped discussion on important topics, and basically made publishers scared of being sued. The costs of defending libel cases were incredibly high, and they pointed out that big companies, organizations could use the threat of libel action to silence critics.
And it wasn't just publishers, right? They also mentioned academics being afraid to publish research.
Yes, that too. It impacted scholarship. Money was being spent on legal advice instead of, actual research or cultural work. All these fears, they argued, led to self-censorship. Important information just wasn't getting out there.
Yeah, you can see why reform felt really necessary. Okay, let's get into the details then. What counts as a statement in defamation law? It's broader than you might think, isn't it?
It really is. The law defines it very broadly. It's not just words written or spoken. It can be pictures, visual images, gestures, basically any method of signifying meaning. So theoretically, yes, even an emoji could potentially count in the right context.
That's wild. Now, historically, there was this big distinction between libel and slander. Can you break that down for us?
Sure, it's an old distinction. Libel traditionally referred to defamatory statements made in a permanent form. Think writing, printing, recordings. Slander, on the other hand, was for statements in a more temporary or transitory form, typically spoken words.
And that difference used to really matter, right? Like printing something nasty was seen as worse.
Exactly. Putting something in print suggested more malice, maybe, and it could cause wider, longer-lasting damage because it was permanent. So writing a nasty rhyme about someone could be actionable libel, but just saying the words out loud might not have been, or at least it was harder to sue for.
So libel would be things like a newspaper article, an email, and a political cartoon.
Even a waxwork. There was an old case involving Madame Tussauds. Permanent just means not transitory, not necessarily forever. Even a deleted email was permanent when sent. Slander would be more like everyday conversation, maybe a gesture.
Okay, but what about modern tech? That must blur the lines, like a voicemail. Is that permanent or transitory?
That's a tricky one.
Or a live video call, especially if it's recorded, or lots of people are on it. And what about Instagram stories that disappear?
Yeah, these definitely challenge the old categories. Voicemail is probably treated like dictation, the speaker commits slander, but the recording itself could be libel. Live video calls. It's debatable if they're purely slander, especially if recorded or multi-person. That adds a layer of permanence. But the good news, in a way, is that the practical difference between libel and slander is much less important now. Since the 2013 Act, that serious harm requirement applies to both. You used to assume harm for libel, but not anymore.
Right, the serious harm test. Let's dig into that. Section 1 of the 2013 Act. What's the core idea?
The core idea is simple. A statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. It was a deliberate move by Parliament to raise the bar, make it harder to sue, and weed out those more trivial claims that clogged up the courts.
So it's not enough for something to be nasty or untrue. It has to cause serious harm. And the Supreme Court clarified this in the Lachaud case in 2019.
Yes, exactly. Lachaud made it clear you can't just assume serious harm based on the words alone. Courts have to look at both the inherent tendency of the words to cause harm and indeed the actual impact the statement had on the claimant's reputation among the people who heard or read it. Claimants often need to bring real evidence of that impact. You can't just say, people must think less of me.
What sort of evidence? What factors do courts look at to judge if the harm is serious?
They look at a few things together, like how many people saw or heard the statement. The more people, the more likely serious harm might be inferred. Who were those people? Did they know the claimant? Harm among people who know you often counts for more. Was there potential for it to spread further, like on social media? Is there actual evidence people think less of the claimant now? And did the defendant deliberately target the publication to cause maximum damage? Maybe by sending it to specific people.
Let's go back to Ronnie, the landscape architect accused of being dodgy. Thinking about these factors, how hard would it be for him to prove serious harm, especially if he can't point to a specific lost job?
It would likely be very challenging. Without concrete evidence, a lost contract, demonstrable loss of income, specific opportunities missed because of that post hitting the serious harm threshold is tough. The law wants to see a measurable, significant negative impact on his professional standing or earnings, not just, hurt feelings or general worry. Proving that direct link from one social media comment can be difficult.
Okay, so serious harm is crucial. But the statement itself also needs to have a defamatory meaning. And this isn't just about what you find offensive, right? There's an objective test.
That's right. It's not subjective. The classic test from the old case Sim v. Stretch asks, would the statement lower the claimant in the estimation of right-thinking members of society in general?
Right-thinking members of society. Okay, so just insulting someone isn't enough, like calling Ronnie a pompous idiot.
Usually not. Courts call that mere abuse. It might be rude, it might be unpleasant, but it doesn't necessarily damage their reputation in the eyes of society. But Haley's comments about Ronnie dodgy, awful attention to detail, aimed directly at his professional competence as an architect. That would likely meet the test. It hits his professional standing.
And this idea of what's defamatory, it changes over time, doesn't it? It's not fixed.
Absolutely. Societal standards evolve. A really stark example is alleging someone was homosexual. A century ago, that could ruin careers. Think of Oscar Wilde. Today, saying someone is gay wouldn't be considered defamatory. It wouldn't lower their reputation in the eyes of right-thinking people. Cases like AVBB, TDD confirm this. It reflects a public policy decision, really. The law doesn't want to imply that being gay is something negative.
That makes sense. But who exactly is this right-thinking member of society? In a diverse world, people think very differently. How does the law handle that?
That's a great question, and it is a challenge. The right-thinking member of society is a legal construct, a bit like the reasonable person in negligence law. The courts have to apply it. Take the Shah v. Akram case. Someone was accused of insulting the Prophet Muhammad. The court said this was defamatory, even to a hypothetical non-Muslim, ordinary, reasonable Englishman. Their reasoning was that even someone who didn't share the religious belief would still think less of a person who would go around insulting someone else's deeply held religious beliefs. It suggested they were disrespectful. It's quite a complex judicial idea.
Wow, okay. And what about the words themselves? Words can mean different things. Context is everything. How do judges deal with that, especially online?
This came up crucially in the Stalker v. Stalker case in the Supreme Court. Nicholas Stalker wrote on Facebook that her ex-husband tried to strangle me. The lower courts looked at dictionary definitions of strangle, which often imply to kill. Nicola couldn't prove he actually tried to kill her, but the Supreme Court overturned it. They said, you have to look at how an ordinary reader of a social media post would understand it. And they'd likely understand tried to strangle me as meaning he grasped her by the throat, not necessarily that he attempted murder.
That Stalker case feels like a real moment, doesn't it? The law having to grapple with how people actually communicate online, not just dictionary definitions, thinking like a Facebook user, essentially.
Exactly. It's a massive shift in how we have to interpret meaning in this digital context.
So can you give us some clear examples? What kinds of things are generally seen as defamatory?
Sure. Things like calling someone a homewrecker in a specific context, using racist language, saying a business is going bust when it isn't, or accusing a ship owner of having an unseaworthy ship. These things directly hit reputation.
And what about things that are generally not defamatory? Is there a policy reason behind those?
Yes. Often public policy is key. Saying someone has changed their gender isn't defamatory, nor is saying someone has suffered from mental health issues, or saying someone reported criminal activity to the police. The law wants to encourage that, not stigmatize it. In these cases, the courts are essentially saying that a right-thinking person shouldn't think less of someone for these things, preventing the law itself from reinforcing prejudice.
Okay, got it. So we have serious harm, defamatory meaning. The statement also has to actually refer to the claimant. Seems straightforward.
The basic idea is simple, yes. The statement has to be about the person suing, but crucially, the person making the statement doesn't need to have intended to refer to them. If a reasonable reader might think it refers to the claimant, that can be enough. That was the issue in the old Holton v. Jones case, where a fictional character was mistaken for a real person with the same name.
Right. And what if a whole group is defamed? Can everyone in the group sue?
It depends. If it's a small, clearly identifiable group, like in Barron v. Collins, where it was 3 Labor MPs for the Rotherham area, then individual members can often sue. But if it's a very large, undefined group, like all lawyers or all residents of London, then generally an individual member can't sue. It's just too broad.
And what about defaming someone who has died? Can their family sue?
No, not under English law. Your reputation is only protected while you're alive. The right to sue for defamation dies with you. Friends or family can't bring a claim on behalf of someone who's passed away. The Dugashvili v. Russia case involving Stalin's grandson confirmed this principle at the European level, too. Reputation rights end at death.
Okay, so serious harm, defamatory meaning, reference to the claimant. The final piece is publication. Now, this doesn't just mean printed in a book or newspaper, does it?
Not at all. Publication in defamation law simply means the statement has been communicated to at least one other person, a third party, someone other than the person making the statement or the person being defamed. Traditionally, even telling just one other person was enough to count as publication.
But wasn't there a concern that this made it too easy to sue? That it created a chilling effect on free speech? What does that mean?
A chilling effect is when people or publishers hold back from saying things they self-censor because they're afraid of being sued, even if the claim might not succeed in the end. It stifles debate. Because of this concern, courts started using their power more readily to strike out claims early on, especially if the publication was very limited and the potential legal costs seemed completely out of proportion to any actual harm caused. It was a way to stop the system being abused for minor incidents.
Can you give an example of that, like the Liberty Fashion Wears case involving Primark?
Exactly. Primark put a press release on its website about canceling a contract with Liberty due to an unsafe building linked to the Rana Plaza disaster context. Liberty sued. But the court struck the claim out. Why? Because evidence showed the web page was only viewed 151 times globally. Many views were actually prompted by the lawsuit itself. The court said the publication was so minimal, the litigation costs would be totally disproportionate. It just wasn't worth pursuing in court.
That really shows the serious harm and publication elements working together. So back to Ronnie's social media post one last time. If you were looking at that Facebook post, what specific details about its publication would you need to know?
Oh, you need to dig deep. How many members does that specific Facebook group have? Is it a closed group? How active is it? How defined is the group, local mums, specific school year? Is it moderated? And crucially, is that post searchable? Could someone find it by searching for Ronnie's name on Facebook or even on Google? All these details about accessibility and the potential audience size are vital for assessing the extent of the publication and the likelihood of serious harm.
Right, so bringing it all together. To make a successful defamation claim, you generally need these 4 things. 1, the statement caused or is likely to cause serious harm to your reputation. 2, it had a defamatory meaning in the eyes of a right-thinking person. 3, it clearly referred to you. And 4, it was published to at least one other person. And interestingly, the claimant doesn't usually have to prove the statement was false. The burden often falls on the defendant to prove it was true if they use that as a defense.
And that brings us right back to where we started, that fundamental balancing act, protecting reputation, which ties into our right to privacy and family life, versus upholding freedom of expression. Defamation law is constantly trying to walk that tightrope, and it's a process that never really ends, especially as society and technology change.
Absolutely. And as we finish this deep dive, it really makes you think about the future challenges, doesn't it? Especially online. What about things like dead naming someone? Is that defamatory? Should there be a right to insult online? How do we handle local meanings when statements go global instantly? Could a single text message be enough for a defamation claim? And should we hold every online commenter to the same standards as, say, a newspaper editor? The digital world keeps changing how we talk to each other, and the law has to keep figuring out where to draw the lines. Where do you think the line should be drawn next?